So I've got your motion, Mr. Browning, and I've got your response as well, Mr. Ratigan. Is there anything you want to add, Mr. Browning, before I turn to Mr. Ratigan?
No, just that, yeah, there has been a change in circumstances regarding the size of Mr. Forrest's family. He now has a relationship and he has another child to support of his own with his new partner. And yes, my understanding is it has been some time since the last recalculation.
Thank you. One of the questions I have before I turn to Mr. Ratigan is I understand, and this refers to the parenting time issue that I think was put in there. I didn't know if it was intentional or not, but it's interesting because the case of Merrick versus Merrick, M-A-R-I-K, 325 Michigan Appeal 353, a 2018 case, provides that remarriage of a party would constitute a change of circumstance. To allow me to stick my nose in their parenting time business. But the case does not provide, nor am I able to find any case law that would support the fact that one of the parties had a child would constitute a change of circumstances relative to parenting time. Do you have any research to the contrary, Mr. Browning?
No, I don't. It was just a request, and that can be affirmed or denied in and of itself. But the main point was that, yeah, we needed the recalculation as well.
Okay, I'm going to respectfully deny the parenting time request because I don't think it meets the threshold. But Mr. Ratigan, your response insofar as the child support is concerned.
I'll add only, Your Honor, ever mindful of the court's opening statement today about rehashing, that defendant could have requested this recalculation directly through the FOC via MCL 552517B and didn't, instead blaming that office for a procedural error that never occurred as a Hail Mary to attempt to revisit parenting time, a request that could only have been included in a motion. Considering the history of the case and the defendant's conduct throughout, plaintiff would ask that any order today reflect that should defendant move for a future modification of parenting time or custody and again fail to meet threshold, he be automatically responsible for plaintiff's attorney's fees incurred to respond to yet another erroneous and frivolous claim. There have been several in this case, Your Honor.
Thank you.
That's all.
Okay, thank you. Well, let me just say this. I haven't, and I don't know if I really could or should include an order that would, in essence, an anticipatory order for attorney's fees. Obviously, if Mr. Forrest or his attorney feels like there has been proper cause or change of circumstance, they can bring that to my attention. If it is not a motion grounded well in good fact or it's frivolous, then I would certainly entertain a request at that time, Mr. Ratigan, to award attorney's fees in this matter. But obviously, the guidelines the child support guidelines are implicated when you have another child. There's no doubt in my mind. So there's a couple of different ways we can do this. I got two pretty good family law attorneys in front of me right now. If there's been no changes as far as like income, that type of thing, overnights, whatever, the parties could just send guidelines back and forth and just include that other child now, and go on from there. But if there's other things in there, like income, overnights, health insurance, some of those other things, I would be okay with sending it to the friend of the court and having them do a retool of the child support if you think that's necessary. I'll turn to you first, Mr. Browning.
Well, the overnights have not changed. They're still doing the same overnight schedule they were doing before, so that doesn't change. I'm not aware of whether or not either of the parties' income as such has changed.
Hang on a second, Mr. Browning. Hang on a second. If your client shook his head anymore, he would be knocking the snow off my roof. So I know you were reading something, but I was looking at Mr. Forrest, and believe me, I would love to invite him to a poker party because I'd probably take all his money. But he doesn't have much of a poker face. I think that's probably a good idea, Mr. Radke. What do you think? Send it over to the front of the court and let them do a deeper dive on the child support as far as that goes.
I would agree, Your Honor. I would just impress upon the court again, this has been somewhat burdensome to my client in terms of the history here, post-entry of the judgment. You'll note in the Register of Actions, none of these proceedings have been initiated by my client. And accordingly, my client would ask that if there are any fees associated with that child support review, that defendant pay them.
Thank you. Well, thankfully there are not. So I will do an order of reference to the friend of the court relative to child support. And I just want to say one last thing. Usually, when people request the friend of the court to do a deeper dive into their income, they assume because their income went down that the number is going to go down. That doesn't always hold true because the friend of the court could impute or pretend that the parties make more money if they hear anything about any unexercised ability to earn. So I will just toss that out there, but I will respectfully deny the motion on parenting time, and I will do the order of reference to the friend of the court relative to child support. Mr. Browning, can you do or prepare an order denying your motion for that, but granting your motion relative to child support, please?
Yes, Your Honor.
Thank you. Mr. Ratigan, anything further?
Nothing further, Your Honor.
Well, wish you the best. Happy Valentine's Day. Have a great weekend. Nice to see everybody again. And you can sign off. Thank you.
You as well. Thank you, Your Honor.